everyone. Welcome to our August Navigating I-9 E-Verifying Immigration. We will give folks just another minute to join. We're going to have a packed 45 minutes, so we'll get started pretty close to the top of the hour here, but we're going to give folks just a minute or two to join to make sure we have it. Thanks again for being here. If you can hear me okay, let me know. We're going to be using the Q&A today, so let me know where you're joining us from and that you can hear me okay, and we'll get started here in just a minute. Thanks for writing in there. People joining from all over. And okay, we've got a packed house here today. And for those of you that are joining us for multiple sessions, you know that we have a lot to cover in 45 minutes with latest headlines and things that are happening here. So our intention here is to help you with the ins and outs of the latest regulations that you've been seeing over a tumultuous summer. These are evolving quickly. So this is actually the last in our series of evolving regulations as things have been crazy. I don't know that they are or aren't dying down as much, but this was kind of the set of sessions that we had set together. So really, just before we get started, I know that this compliance landscape that we're in is a wild world right now. So Ben, if you can hop up our first poll. Our intention is to really make this content work for you. We want to know where you're at as you're joining us. If you're at that like intro level, like I know what a Form I-9 is, I may be responsible for it, versus 400 throw TPS acronyms at me all day. I want to understand where they're happening. That's kind of our scale. We'd love to know where you're coming in here today so that we can speak relevantly to the audience. With that said, Kim and I both talk in a lot of acronyms. There's a lot of acronyms in this world. If you don't know what we're saying, other people probably don't either. Please feel free to put it in the Q&A. I'll try and remember to slow down and put those in as we talk through.
Your screen share swapped over to Spotify?
Shoot. Okay. That's always helpful. That's when I know what I'm listening to. Okay, let me pull this back up.
This is good music, Chapelle.
You know, we're good and going. Adele, on my Adele radio? Great. Okay, let me find my workplace. Was that when the poll came up, Ben? Is that when it swapped over?
No, it was before.
Okay. X out here. Apologies, guys. 1 second. Not able to get my deck back. Let me start a new one real quick. Ben, go ahead and share those results. So as I'm pulling this up, people can see where we're all coming in at. There it is. Got it back on my side. Let me reshare. All right, give me a thumbs up. Are we seeing the right thing now?
Yes.
Yep.
Okay, great. Thank you guys very much. Okay. Nope, and then it pulls away, right? Did it just pull away?
Yep.
Yep, it did.
So sorry, guys. 1 second.
Can you do...
When I change the slide, it's pulling away. I will do a different way of doing this. I'll put it on a different screen. Up there. And there's something with the polls that is messing us up on my side. So let's pause on those. We'll find a different way to present it. And Ben, would you pull up and maybe share on your end? I'm worried I'm going to have more problems here with tech.
Yes, no problem.
All right, thank you.
1 second. But you can start your intro.
Yeah. As Ben pulls that up, really apologize for technical difficulties here. I am Chapelle Ryon. I am CEO of WorkBright. I've been in the I-9 space for over a decade now. Live and breathe in this all day with customers. We've processed over 3 million I-9, so we're deep in the weeds of the complexities of what's been happening with changing regulation. I have joining me today, Kim, would you go ahead and introduce yourself as well?
Yeah. Hello, everybody. Kimberley Best Robidoux. I'm a partner with WR Immigration in the San Diego office, and I've been dealing with I-9 compliance since the early 1990s. So for a very long time. I love this stuff, like to geek out on it. And I'm currently chair of our American Immigration Lawyers Association Verification Documentation Committee, which just means that we're thick in the weeds on all of this every day. So good to see you, Chapelle.
Yeah, thanks for being here, Kim, again for the last of our series of a crazy summer. So our plan today, if we can go to the next slide, is going to be talking about some of the latest headlines from the last time that we had this webinar as well. There's kind of 3 that we want to highlight. We're going to talk about some broader trends in I-9, E-Verify, and we're going to bring it home with TPS. In each of these, we're going to give you mitigation plans. So things that you should be looking at within your workforce and within your processes to help mitigate some of the changing things that are happening. And hopefully by the end of this, make you feel a little less scared of the choppy, tumultuous compliance waters right now. Before we jump in, next slide is we are SHRM certified. We're going to be here for 45 minutes. So we'll be sending out QR codes after this. And if you are here to get credits, you can get that for the 45 minutes that you're spending with us today. All right. So let's jump in. First thing we're going to talk about are what's been in the headlines. So this first one we're highlighting, there's not a huge takeaway here, but it's a good early indicator of potential things that are going to be coming in a state-by-state fashion. So this particular one was in Illinois. Illinois at the beginning of the year put in place a bunch of new regulations that were kind of additive to the E-Verify laws that were happening at the federal level. And what happened just recently, and why this is important to all of you, whether you're employing in Illinois or not, is that DOJ was seeking a broad preemption. So had this been successful, this could have really reshaped the way that immigration-related laws are handled at the state level versus the federal level. The courts backed Illinois on this one, so it upheld the state's rights of traditional rules in regulating employment laws within their state. But the reason that we want to highlight it, even though it wasn't successful in the DOJ's attempt, is these are really complex laws that are happening on a state-by-state level, and there is heightened risk for employers that are kind of trying to navigate. Should I be going with federal law here? Maybe I'm okay here. And an ICE auditor that comes in is or is not going to be looking at the state level laws that are associated there. We're not seeing a ton of enforcement at this point at the state level. Kim, can you correct me on that? If you've seen anything just recently in maybe like Florida, Illinois, those that have, we're not seeing a lot of regulation enforcement there at this point, right?
I mean, Florida still is doing their enforcement of their law with respect to employers having to enroll in E-Verify if they have a certain number of employees. But there isn't anything new that we've seen recently from other states. But Florida has been really pursuing those policies.
Yeah. Florida has been regulating a lot. In Illinois specifically, haven't seen a lot of specific regulation enforcement happening with the new laws that are there. But it was upheld that all of these state-based laws that are coming on that are layering on top of the federal laws are being upheld at the state level. So a good thing to keep an eye on. If you employ in multiple states, you know, Google Alerts will talk about some plans there, but this is a good thing to keep an eye on. The next one here, Kim, can you talk to us about ICE issues and the non-retaliation statements that were recently issued?
Yeah, sure. So U.S. Immigration and Customs Enforcement, right, which we call ICE, recently issued a retaliation policy statement or a non-retaliation policy statement telling employers, specifically small businesses, that, hey, if you have a question or a concern about ICE policies, you can voice that complaint or concern to ICE without the fear of ICE retaliating against the employer because they raise those concerns. Those concerns would likely come up in the event of a notice of inspection, right, an I-9 audit. If an auditor is not being very friendly, you know, is overly aggressive or is asking for things that are way beyond the scope of what should be provided in a notice of inspection. If an employer raises those concerns, then ICE is saying that they're not going to retaliate against the employer for raising those concerns. So we'll see how that plays out moving forward. We haven't seen that, as of now, but we'll just keep an eye on it.
Yeah, and it's a great segue to our next one, which is we are seeing just recently, this section is really what's happened in the last 30 days since we all potentially spoke together, if you're a repeat listener of this webinar. We are seeing USCIS, DOJ, ICE issuing a few more support statements around things that have been happening. Maybe it's a little late. We've been trying to interpret stuff ourselves. But a big one is just 2 days ago, USCIS issued an EAD revocation guidance for E-Verify employers. So this is like brand new, hot off the press. We have a link, maybe Ben, if you can put it in chat or Q&A, or we can send it out in follow-up materials. If you're an E-Verify employer, you probably got an email about it if you're an admin in there. But there are new status change reports that are available. We're seeing like legislation coming out and then some follow-up of, oh, let's help employers understand and deal with this legislation. So the first one was big TPS changes and things happening with work status. Now let's make a report available. Then we saw some adjustments to that report because it was various levels of helpful to employers. Now we're seeing some guidance come out. So it's trickling. I think that our governing authorities are trying to respond to what they're hearing from employers, and it's difficult. It's slow moving. Getting answers to these things is tricky. If you're an E-Verify employer, though, you should be logging into your account directly and using that status change report. If you work with a vendor that's an employer agent, you need to coordinate directly with them. The employer agents should have access to the status change report. And it is something that you can only get in E-Verify. So as a software vendor ourselves that integrates with E-Verify, we can't get the information and now give it to our customers, and they just haven't made it available via the API. It really is a downloaded report that's available within your E-Verify section. So for E-Verify employers, a lot of support that's recently coming out to help you with some of the status changes that are happening. All right. Those are the big kind of headlines. Let's jump into some broader trends. For those of you that have been with us multiple times, we'll do this slightly differently, but it's going to be some repeat material. First thing here is just heightened enforcement. So we are seeing a lot more financial incentives going on for employers, for employees to report on employers that aren't acting within. The Big Beautiful Bill Act had a lot of implications as well. So Kim, can you talk a little bit about that act and what it means for the heightened enforcement that we're seeing?
Yeah, so I mean, the government now, specifically Department of Homeland Security, has a lot more money in order to do investigations as well as to fine companies by doing these further investigations that will allow them to dig in a little bit more. We're also seeing that, one of the policies that was implemented under Biden has recently been changed to incorporate immigration violations. So members of the public can be whistleblowers, so to speak, if they see that, hey, an employer is not completing the I-9 process properly, or they're overlooking things, or they want to file a complaint. If it results in some type of order against the employer, then that individual, that whistleblower, potentially can receive money for their filing of that complaint and alerting Department of Homeland Security to something that an employer is doing that is not legal or not in compliance with I-9 and E-Verify issues.
Yeah.
Yeah.
And there's a good question in the Q&A, which I think kind of goes to this. They're saying, like, should we or should we not be running the status changes to avoid audits? And these things are kind of like pulled apart a little bit. Short answer is yes, you should be running that report. If you don't have a report, if you're not an E-Verify user, it is still your responsibility to understand who you are employing, under what status, and to take appropriate action with the status of that employee. So the E-Verify report is there to support you in identifying where there could be issues with these status changes happening within your workforce. But whether you use E-Verify or not, you need to know who's in your workforce right now because of this heightened enforcement that we're talking about. So we are seeing, traditionally it was tip-based. Under the Biden administration, there was a lot of tips coming forward, which would then result in an audit. We're talking like around 300 in the last year of Biden's administration. In the peak of Trump's first term, there were over 6,000 audits. And this Big Beautiful Bill Act gave a lot more financing to ICE and other departments to do more of these audits. So E-Verify status change report, whether you have it or not, you need to know what's happening. And there are certain industries as well. Kim, who are you seeing being targeted for notices of inspection?
So there's a lot in the hospitality industry as well as manufacturing and construction. Those are the heightened industries right now that we're seeing actions taking place. There's also some, with meat packing, and then in California, we've had some agricultural in the cannabis area, but those are the main industries lately.
Yeah, that's what we're seeing as well. Hospitality, food processing, staffing, and construction being kind of top of this list. Yeah. Okay.
Yeah, and just one thing to add, Chapelle, with an employer having access to that E-Verify status change report, it could be considered by ICE that an employer has constructive knowledge that an employee does not have valid authorization to work in the US, with the fact that the employer has access to that chart. So if an employer fails to take action or fails to review it, it could significantly harm the employer during the course of a notice of inspection if they're audited by ICE.
Yep, that's a great one. And a great question before we move on in the Q&A on this. With PEO specifically, they should be pulling that and communicating with the employers directly who they need to approach and kind of doing that in tandem. Would that be your guidance there as well?
That's correct. Yep.
Yeah.
Absolutely.
All right. We got a lot. I know there's a lot of questions around the status change report. We'll see if we circle back to those on E-Verify, but let's move on to identity fraud vulnerabilities, because this is a big one that's happening as well. So if you are an E-Verify user, that is a additional step of validating and running your employees through workforce authorization, okay? The big hole, though, with E-Verify, and there's even been public statements coming from our regulating authorities around this, is if someone steals the identity of an individual who is authorized to work and uses that to prove authorization, there's no catch for that. So this is a big hole, and with the introduction of AI, identity fraud, creating fraudulent documents, all of this is a increasing threat to employers who are really trying to do the right thing and run people through the right processes. It's just a new added challenge, and there's not a lot of great systems out here to do this. So quick poll, because we're curious on this. Who's actually addressing this? What are you seeing? How are you thinking about this? On the WorkBright side, we introduced a tool called document verification, which can catch fraud that is created on documents. Has this information been manipulated around here? But this is a big one that we're seeing a rise of with the introduction of AI, that there's more identity fraud happening, and then that identity is being used to prove work authorization. And then employers are caught in the middle of this, needing to look at that. So Kim, how would you advise employers to think about this rising challenge? What are you advising them to do as an additional step, or not to do? Because it says very clearly if this appears to be genuine. So what are you advising clients on right now on this?
Yeah, so the biggest thing, which is what we've advised for many, many years, is that an employer is not a law enforcement officer. So you only have a certain level of expertise or knowledge when looking at the documents. I do recommend that employers stay abreast of what's in the M274 handbook for employers, as well as I-9 Central. Look to see what are the versions of certain documents, like the permanent resident card and the employment authorization document card, in order to familiarize yourself with the current versions. That's one way to do a good job of doing your due diligence to ensure that you're doing the best that you can to review a document and see if it compares to what's been provided as an example by the government.
Yeah.
Homeland Security Investigations has actually said that with the use of AI, some of those fraudulent documents out there even get by the auditors, right? So that's one thing. As humans, there's going to be documents that get past people, but just make sure that you have those processes in place and utilize what the government has provided with respect to examples of what the documents look like.
Yeah, I think I agree with all of that. The one thing I would just add for consideration for employers, especially those 20% of you that have already put some things in place to help catch this, if you're not doing additional steps to maybe make sure that your employers that come in are who they say they are, the risk is you have a big audit or raid and you lose a large portion of your workforce because it's uncovered a different way. So it can be disruptive to your business in other areas as well if you're not putting in additional protections to make sure that you're not subject to identity fraud within your workforce. Yeah. Okay. Let's move on to this last one. And I saw a couple of questions in here around evolving I-9 completion methods. So I'm going to start with something that's going to feel a little bit old, but we still have employers that are coming to us with, because there was a lot of confusion around this. So during COVID, there was an alternative procedure that was available to complete Section 2 documentation review virtually over a video call because of the restrictions with COVID. Employers were leveraging that broadly. A few days before they had to reinspect those when that regulation was ending, they came out with a new method called alternative procedure where you could do a version of virtual review if you are an E-Verify user. There's a couple of additional requirements in there in good standing, some other things that say whether you can or can't use a video call to review Section 2 documentation. However, the thing I want to be clear about, because there's just a lot of confusion around this, is because you did virtual review before during COVID, and now it is acceptable in certain instances to be able to do that again, that does not mean that all of your COVID ones are now okay. You still need to have all of those Section 2 documentations re-inspected. In certain use cases, you can do it via another video call, but you do need to note and have all of your employees in there that were completed virtually over that COVID period re-inspected, okay, with an acceptable method of Section 2 review. So just in case there was any confusion out there, let me clear that up. If you are using alternative procedure, this is a new thing. This is good for employers. There's a reason people are using it, especially in remote environments. You can't be using that universally. You need to make sure that you adhere to the standards that they put forward for users. The number one being that you are an E-Verify user. The last thing that I'll say on this before Kim, I just want to get a little reflection from you on what you're seeing as practices for employers. The use of an authorized representative for the completion of Section 2 review has always been in place. That's not new. That's not post-COVID. That has been a part of this, that you could have an authorized representative. Does not need to be someone associated with your organization. Complete the physical in-person review of the Section 2 documentation. Now, employers have struggled to do that because, one, how do I verify that it actually happened? And two, how do I know that this person that I've authorized knows what they're supposed to be looking for on these documents the same way an internal HR person has done? There are vendors, I'm not going to, WorkBright being one of them, that has created technology solutions to support that authorized representative process so that it can be done compliantly and with assurance by the employers that they can overcome those two objections of how do I know it happened and did the person know what they were supposed to be reviewing. So there are a lot of options for Section 2 review at this point: physical examination, authorized representative, alternative procedure. Kim, what are you seeing from clients right now? Which one are they leveraging? What's working well for them? What are you recommending on this?
Yeah, it really depends on the type of organization and what their workforce looks like, right? If they have a lot of remote employees, using a vendor that allows them to complete everything remotely and not use the friends and family program, so to speak, they feel a level of comfort with that. Some smaller organizations, if they have a few people remote, have been still using we'll call it the designated representative or family and friends process. When using that authorized representative, then it's really important that the company have a clear policy and process in place, provide that written guidance to the employee and the authorized representative. And then when that Section 2 and Section 1 comes back to the employer, they really need to make sure that they're reviewing that thoroughly so that if there are any corrections or edits to be made, that they can make it as necessary. So a lot of the designated rep or the authorized rep is with companies that are still utilizing, the handwritten paper I-9s.
Yep. Yeah, and we have a great question in here about can this only be used for remote employees, the virtual review, or can it be used for all? The quick answer back to that is not only can it only be used, it needs to be applied to all of your employees kind of universally. There are some exceptions to that with hiring sites. The important part here is that you have a documented process and that you're not picking and choosing when to offer virtual review to certain employees, that it is kind of universally applied across a policy that you've created of the way that you review Section 2. Okay. Anything you'd add there? Did I represent that correctly, Kim?
Yeah, it's really important not to have any discriminatory or what looks to be a discriminatory policy. So you make sure that you have it very clearly spelled out, and so that no one is there to complain that they were discriminated against.
Yeah. And I'm seeing in the questions, there's still some confusion. So I'm going to say this one more time. I'm going to summarize it before we move on. And Ben, while I go through this, go ahead and pop up that second poll of how you're currently completing Section 2 completion. Physical inspection of documents for I-9 is the gold standard that has been in place forever that most people think. That is still an acceptable method for Section 2 completion. You can also use an authorized representative, which is someone not necessarily associated with your organization that can complete that physical in-person inspection. Now there's also an alternative procedure virtual review that is available to some employers if they meet certain standards. Okay, so all of these are available to you as an employer. All right.
I would add, Chapelle, to make it clear, right? Alternative procedure is only if an employer is enrolled in E-Verify and in good standing.
And that good standing is a tricky one. What does that mean in your opinion?
It means that an employer, if they are enrolled in E-Verify, has regularly been using E-Verify for all new hires. Sometimes employers forget that they're enrolled in E-Verify and then they haven't completed cases. So they could not be considered in good standing in that respect. So those are some things to consider.
Yeah. And I see here a question about, like, if I'm using a system that completes my I-9s and uploads IDs, do I still need to do the physical inspection? The short answer is yes. Like, I think there's a big misconception that when we work with software vendors that use I-9, like WorkBright, that it's just kind of hands off, like the whole I-9 process is completed. You still, as the employer, have responsibility for understanding the way that that vendor is processing your I-9s and what your responsibility is in it. And in any case, there's always a Section 2 review of documentation. The vendor can help you facilitate that, but you need to understand what that process is that they're using, that you're using. And to Kim's point about in good standing with E-Verify, that if you're an E-Verify employer, that you're handling cases as they come back, that you're handling your T&Cs in the right amount of time, that you're resolving photo matches. So all of these are not, you can't, like, this is a really hard part of your process to hand off to a software vendor. There's always a partnership. We can make it a lot easier for you and your employees, but there's always a negotiation between the two of what that process looks like now in this world with the software vendor. Okay. All right. This is so interesting. We still have, I'm just going to share this real quick. 75% of you are still using in-house representative with a physical inspection. So there are other methods that may be worth exploring to speed up the time with which it takes people to get completed. We also all know that employees come in on the first day without that documentation. You have 3 days to do it. There's a lot of reasons to look at some of these other methods if that's an issue for you, of getting this completed timely and accurately is an issue. All right. Before we move into TPS stuff, let me just do a couple of quick mitigation plans. So next slide here, Ben. All right, so first thing we're going to ask you to do, evaluate your processes. If you're not sure, we kind of just talked about this with a vendor, without a vendor. Very important that you have an internal document that is published to your HR team, whatever internal knowledge base you have, of the way that you process work authorization for your employees and your Form I-9 and E-Verify processes if you use E-Verify. So standardize that across all stakeholders. The way we like to think about it as WorkBright is like, do we have the process right? Step 1. Have we trained everyone on the process? Step 2. And step 3, do we have accountability for people following that process? Make sure all 3 of those are in place for your Form I-9 processes. Second thing, given the heightened enforcement we just talked about, it may be a good time to conduct an internal I-9 audit. This can be a spot check. You can do a random sample of 100, have these been completed on time, document that you're doing that audit, and then complete the audit and remediate any mistakes. So we're not getting big into remediation here, but in case I don't need to say it, never white out. You're always crossing it out with your initial that you caught the mistake. The auditors that are coming in are just people, right? They're going to look more favorably at that you identified an error and took corrective action on it than if you tried to conceal or hide that there was an issue. If you discover that there are broad issues within your I-9s, like maybe Section 2 wasn't being completed because we thought that it was handled with an I-9 vendor that it wasn't, I'm going to highly advise that you work with a specialized attorney, like someone at Kim's firm, to understand the processes you should go through to get those I-9s in good standing ahead of an audit. Much better you discover it now than with an ICE auditor at your doorstep, okay? And while we're looking at all those I-9s, while we're going through and doing our audit, document your TPS statuses. The things you need off of those EAD cards to understand this are the category code, country of origin, and the expiration date. That's not information that is publicly available on your I-9s. It's stuff that you need to keep separately somewhere. It's a little unprecedented. We're going to talk more about TPSs, but this is something that employers have been really struggling with, to understand who in your workforce is here under which temporary protected status. Okay. I already talked about this. If we have issues, involve specialized counsel, certainly, and then develop response protocols for potential enforcement actions. Kim, talk a little bit about what you're seeing of like jumping from NOIs to inspections and what's changed a little bit there from what could have been, and why it's so important to understand what happens if someone shows up at your door.
Yeah, so there's a few different worksite enforcement actions that can take place. There's a knock and talk where someone from Homeland Security Investigations comes in and asks, hey, I just want to talk to you about your I-9 process. How are your forms? Blah, blah, blah. You have an absolute right to say thank you, but no, don't talk to them, because it isn't always a very friendly conversation. It can be very friendly, but it can be used against the employer. So you have the absolute right to say no. Then there's also if HSI or ICE comes with a warrant, there could be an administrative warrant or a judicial warrant. If it's an administrative warrant, you can accept it, talk to counsel, determine if you're going to reply, how you're going to reply, and say thank you, let them go away. If it's a judicial warrant, then you actually have to look at it, step back, don't obstruct, but document what you're seeing. Make sure that the warrant is for your particular work site and that they're staying within the scope of the warrant. If they are not, document it, and then you can deal with it after. Again, call counsel. And then there's a notice of inspection. And a notice of inspection, there's always an agent and an auditor from Homeland Security Investigations. They'll issue the notice of inspection saying you have 3 business days to turn over your I-9s, and they usually will ask for some additional documentation and an immigration enforcement subpoena. When working through that process, the next thing is usually the auditor reviews, and then we'll issue a notice of technical or procedural failures. And then from there, they might issue a notice of suspect documents saying, hey, we've reviewed the employees and the I-9s, and something about this employee's A number or social security number do not match what's in the government system. So that's a notice of suspect documents, especially giving the employer notice that these individuals are not authorized to work. We have seen in some instances where ICE is essentially going from the notice of inspection to a raid, where they're getting a judicial warrant to come into the work site and essentially detain individuals or gather additional documentation, because based on their initial review, when they received the I-9 documents and the copies of the documents from the employer, they ran everything through their database, found individuals who were not authorized to work. So instead of going to the notice of suspect documents, they're going directly to detaining individuals, which in a way goes along with, the quota right now to detain and deport as many people as possible. It's not a widespread action going right from notice of inspection to a judicial warrant for a raid, but it is something that we have been seeing happen.
Yeah. I mean, what a jam-packed, succinct way to put all that. Thank you, Kim. I saw some questions coming in. This is being recorded. You will get a copy if you want to put that on slow and repeat everything that Kim just said, because there was a lot of gold in there. I think hopefully what you got out of that is these are unique, changing cases. It is good to have your counsel involved. We've been seeing a lot of general counsel within organizations suddenly getting very interested in the I-9 processes of your organization. And I'll just say it is hard even for lawyers to understand this stuff. Working with specialized attorneys that are in this every day can really help, just having one on call, so that if someone shows up at your door, you can walk through the way that Kim just did, what action to take next. So thank you, Kim, for summarizing that the way that you did. Sure. Let's move on to mitigation plans for E-Verify users. I know not everyone on here is an E-Verify user, so I'll cover these at a pretty high level and leave us a lot of time to talk about TPS, temporary protected statuses. So with E-Verify, first thing is confirm your specific requirements. If you hire across multiple states, you need to know what the E-Verify requirements are in each of those states, and they do change. Okay, so Florida had some changes just recently as well. You need to know what those are and have Google alerts or a specialized counsel that is monitoring this so that if there are changes, you can continue to comply with those. Map your requirements across all the operating states if you're a multi-state employer. And then there's also some federal contractor FAR E-Verify obligations if you work with federal contracts. So know what the E-Verify requirements are for your specific situation, and then optimize your E-Verify processes. So just like we said, have a plan for your processes, train on it, and then hold accountable to it. You need the same thing for what happens when a TNC comes back. Who's responsible for photo matches? In what time do we respond to those? You need to have all of that documented, ideally with owners of who those people are so that you can hold them accountable if it's not happening. Audit your E-Verify history to make sure that there's no compliance patterns or issues within what's happened historically. So same things applying to I-9, applying to E-Verify here. Train your staff on proper verification procedures and documentation. Last thing here is strategic enrollment. So Kim, I want to turn this one over to you. There are instances when you are not mandated to be an E-Verify employer, when you may choose to enroll in E-Verify. It is optional for employers across the US. So how are you advising clients in this? How are you considering strategic enrollment at this point?
Yeah, so for some instances, an employer might want to hire individuals that are graduates of US universities and colleges, where initially they have the first 12 months of optional practical training. And then if they're in a STEM field, they can get up to 24 additional months under the STEM OPT extension. And in order to be able to get those additional 24 months, the employer has to be enrolled in E-Verify. So if an employer is looking to hire, new graduates that have STEM degrees and want to be able to employ them for more than just a year, that's a strategic way of going about enrolling in E-Verify. Also, with looking at what type of industry is a company involved in, it might be something that is best to find out in advance, that the individual's information is matching what's in the government system. Obviously, talking about identity theft that we can't get rid of via the E-Verify program, but that might be something as well. Is look at what is the industry that the employer is in, and is it something that's going to be beneficial for them in the long run, in the event that they were audited by ICE. But those are some of the things to consider, as well as administrative time, because it does take a little bit of time. Even though it's a free system, there's that additional time that someone at the company will have to put in order to make sure that the cases are completed and submitted timely.
Awesome, thank you.
Mm-hmm.
Okay, I'm going to move us on to our last stop because there's been a lot about temporary protected statuses. I also just want to comment, man, your questions are so good and they're juicy. We're talking about notaries and retention requirements, things that we may not have time to get to in these 45 minutes, but we're going to make sure that members of our team that are trained in this follow up with some good answers because they're awesome questions. So keep them coming in, and if we don't have time in here, we'll make sure to get you an answer after the webinar. So our last step here is going to be in TPS changes, temporary protected status. DHS has been providing TPS status updates even like last minute. There's been a lot of change in here. Like I said, this is a really unprecedented time of people that were previously authorized to work that may no longer be because of changing administrative policies that are coming into place for workers of certain statuses. So effective July 22nd, there have been new fees applied to immigration applications that were postmarked after this date. There's a lot happening here. Kim, I'm just going to kind of open this up to give the high level. What are you seeing in TPS revocations? Maybe even let's skip to the next screen here, Ben, which countries have TPS, so we can talk through the things that are most pertinent right now to employers to have an eye on within their workforce. So Kim, can you talk through the slide a little bit?
Yeah, so I mean, this slide has the countries that have been designated for TPS, and we've seen over the last several months, I guess, and essentially since February, that Department of Homeland Security Secretary Noem has been terminating a lot of the TPS designations, and then there has also been a lot of litigation around the termination of these designations. I mean, DHS and the Secretary have that discretion to make a determination if a country no longer meets the requirements for TPS designation. But there's just been some concern about how those policies and the terminations have been decided. So what we're seeing right now, there's a few that are hot and heavy, I guess, with litigation. There's Venezuela. There's a 2021 designation and a 2023 designation. The 2021 Venezuela designation is ending September 10th. There is some question about, well, do they get an automatic 6-month extension because there wasn't anything stated by DHS in July, but the government is taking the position that the previous announcement that they made in the Federal Register essentially terminates 2021 Venezuela, which is September 10th. There might be a court case, a lawsuit filed against that, but that's what we have right now with 2021 Venezuela. With 2023 Venezuela, if individuals filed an extension or received an approval notice on or before February 5th, then it's valid until October 2nd of 2026. Otherwise, that expired back in April. And then the three most recent, where we just had an update from USCIS on their website this week, is for Nepal, which there was litigation that extended TPS for Nepal, Nicaragua, and Honduras until November 18th. The Ninth Circuit Court of Appeals ruled that that extension is, or the district court's decision was not upheld, so that extension was reversed. So it meant that TPS for Nepal expired on August 20th, which is last week. And then for Honduras and Nicaragua, those are set to expire on September 8th. So there's a lot going on in that arena with TPS. It's a brief summary there.
Yeah, thank you. And a ton of information in here. Ben, flip to the next slide for the action plan, just so we can talk about what to do with all of that information when your head's like, where am I and who am I employing and what does this look like? First thing is inventory. So I mentioned this, I'll just say it again. You're going to want the category code and the expiration date. Those are going to be the two most important things that are going to help you identify who in your workforce is under which temporary protected status. And so review those and inventory them. You can create an Excel document to keep these things set. If you're an E-Verify user, use that status change report. That's going to be your most helpful thing to know when statuses have changed for employees within your workforce. If you're a WorkBright user, we have a TPS and an EAD workflow that we're offering now as well. So please reach out to our sales team, maybe on the next slide, and we can talk to you about how we're supporting employers with identifying these in their workforce and then taking action on them moving forward. But the first thing is just evaluation and then set your Google alerts. Okay, so if you find out that someone's here under Venezuelan status, you need to know that. You should probably inform your internal counsel and perhaps your specialized counsel about what to do. I always advise that we consult with counsel, especially if we're looking at terminating someone because of a change of temporary protected status. You need to give them the opportunity to present current new work authorization using Supplement B. A re-verification is where you start. And then if they can't provide that, meaning their temporary protected status has changed and they're no longer authorized to work, make sure you're consulting with counsel through that process so that you're doing it on the right side and not looking at any discrimination charges potentially down the road. So a good example of this, just to kind of, Disney World has placed 45 Venezuelan employees on unpaid leave following the Supreme Court's decision. They're giving them 30 days to obtain new work authorization or face termination. So that's an example of how that process could go if you find that you have these workforces within there. Anything you'd add to that on what to do with all of these EAD statuses now?
Yeah, it's really create a process and review the documents that you have and put that policy into place. I did want to mention with the E-Verify status change report, it's unclear right now if they're only updating EADs based on the parole programs or if they're putting TPS in there as well. So I wouldn't rely 100% on the status change reports for TPS termination. So your recommendation to make sure that the employer's looking at the actual documents, collecting that information to be aware of who might be in that situation and take action on that is really critical right now.
Yep, that's a good one. Okay, last slide here. And again, so many amazing questions. We're going to get answers back to you in email because we're at our 45 minutes and I want to be respectful of everyone that broke off the time here. Throw up that last poll here, Ben. We have Kim's information up here. If you'd like to get in touch with WorkBright because you have pain and you need some help managing these I-9 processes, we are here to support as well. We can give you more information, answer your questions. Kim and her team are here for more specific questions, especially in the cases of audits or action that needs to be taken, a phenomenal resource for that. So we'll throw up this last poll here if you want to get in touch with us, and we will come back on a couple of these questions via email. Let me just see if there's any big ones that would be applicable to the whole audience. There is going to be a recording of this after. Let's see. Oh, here's a good one. If we do a self-audit, Kim, and discover that there's issues with terminated employees that are no longer active, what should we do to take action on those?
Well, Section A cannot be changed because only employee can make changes to Section A. With respect to Section 2, I would speak with counsel. Typically, a change can be made as long as you have a certain process in place and you have copies of those documents. But with anything in that respect, I would ask, definitely speak with counsel. But don't touch Section 1 for sure.
Yeah, don't touch Section 1. That is for employee only to be completing. We are at our time, so I'm going to just take these questions in because they're pretty specific. Really appreciate you guys spending the 45 minutes with us today on what is maybe a dry topic, but hopefully we made it a little more clear for you and we're into these clearer waters you see here. For those of you that joined us throughout the summer on these webinars, we really appreciate you being here with us and I hope to hear from you soon. And Kim, thank you for being my co-host on these all summer. I really have enjoyed doing this with you and look forward to more to come.
Thank you. It's been fun, Chapelle.
All right.
Have a good one.
Thanks, guys. Thanks for joining.
Bye.